elective course Ethics and Medical Jurisprudence, second BHMS professional course CBDC. This is module 4 about Indian medical jurisprudence. Lecture 2, topic is legal responsibility of homeopathic practitioner. Myself Dr. Ragini Raut, MD Home, HOD, Associate Professor, Department of Forensic Medicine and Toxicology, Bharati Vidyapeeth Homeopathic Medical College, Pune. Lecture 2 conducts about the legal responsibility of homeopathic practitioners. What is role and duties and responsibility in respect of homeopathic practitioner. The first is medical negligence and malpractices. Second is legal duties towards the patients, case laws and landmark judgments, regulatory bodies and their functions. Medical negligence and malpractice. Homeopathic practitioners in India are liable and there is medical negligence or malpractice. It is deficiency and failure to execute reasonable care and skill or willful negligence act of a medical practitioner which causes some harm or bodily injury or death of the patient. Negligence may be act of omission or act of commission where reasonable man under the circumstances would not do or do. So, these are the do's and don'ts in relation with the physician. As per the Bachelor Dictionary, there are 4 essential ingredients to cause negligence. One is duty, second is dereliction, third is direct cause and fourth is damage. Medical practitioner has a duty to treat a patient with reasonable skill and care. If he is not executing that duty, it will be amount to negligence. Medical negligence and malpractice. The doctrine of RES, that is ipsa liciter, means thing speaks for itself and the patient need not prove negligence when this doctrine is applied. The burden of providing the innocence lies upon the doctor. Some of the examples are burns from application of hot water, breaking of the needles when injections are given, blood transfusion mismatch hazards, too tight plaster cast causing gangrene. Negligence are of 2 types as per law, civil negligence and criminal negligence. Defense against medical negligence, that is calculated risk doctrine, then contributory negligence, vicarious liability and corporate negligence. Fifth is products liability, sixth is medical maloccurrence, seventh is therapeutic misadventure, eighth is error in the judgment, ninth is res indica, 10th is res judicata, 11th is composite negligence. Precautions to avoid negligence stare. First is doctor should get informed consent from the patient. This is very important aspect. He should establish a rapport with the patients, that is doctor patient relationship. He should keep full and accurate medical records, that is record keeping is again important phenomena. Then employ ordinary skill and care throughout the treatment. Do necessary blood tests, X-ray and indicated investigations to arrive a diagnosis. Wherever it is indicated and required, one should ask for the investigation. Immunization should be done whenever necessary, particularly for the tetanus. Sensitivity tests should be done before full dose of injection, that is a trial dose should be done before giving the full dose. Get the opinion from the other doctor if it is necessary. In suspected cases of malignity or necessary tests should be done before injections. The conditions of the patient should be informed to the relatives in the critical situations. Do not give too much promise to the patient. Do not guarantee a cure or do not claim for the 100% cure. Each steps of the treatment must be conveyed to the patient or to his relatives. If the facilities are inadequate, refer the patient to other institute where the facilities are available. In the 15th point, the multi-stage treatment specific and separate consent should be taken at each stage and the patient should be informed about it. When a new drug is administered, strictly follow the guidelines laid down by Indian Medical Council research, that is ICMR. Keep the operation theatres sterilized and infection free. In case of differential diagnosis, the reasons, symptoms and the clinical findings supporting the same must be meticulously recorded. Effort must be arrived at a final diagnosis if possible, and the same must be recorded. Every medical act must be accordance with the prevailing practice acceptable to the doctors of that specialty. Record meticulously the changing clinical profile of the patient and the steps taken to diagnose and manage the same. Medical indemnity insurance. It is a contract between the insurance company and the doctor to compensate in professional negligence in return for the payments of the premium. The objectives of medical indemnity insurance is to protect the professional interest of the doctor, to pay the conduct of defense of doctor in medical negligence, to compensate the amount the court declares to the opposite party. Homeopaths are liable under the laws Indian Penal Code, that is IPC 1860 section 304A, causing death by negligence, section 106/1 BNS 2023 and 338, causing grievous hurt by act of endangering the life, section 125 BNS 2023. Consumer Protection Act 1986. Homeopathic practitioners can be held liable for deficiency in the service. The medical practitioner against whom a complaint is made or the complaint fails or omits to comply with any other made by the district forum, the state commission or the national commission, as the case may be, such medical practitioner or complainant shall be punishable with imprisonment for a term which shall not be less than 1 month, but which may be extended to 3 years, or with fine which shall not be less than 2000 rupees, but which may extend to 10,000 rupees, or with the both. Medical Council Act 1956. Homeopathic practitioners registered under this act can face disciplinary action for professional misconduct. National Commission of Homeopathy Act 2020 regulates homeopathic education and practice and provides for disciplinary action against practitioners. 3 principles of homeopathic practice: the law of similars like, cures like. One of the 3 principles of homeopathy in the law, similars, similia similibus curantur, which means like cures like. The individualization of the case, the minimum dose. Indian Medical Central Council Act 1970 regulates Indian medicine including homeopathy and provides for disciplinary action. Clinical Establishment Registration and Regulation Act 2010 regulates clinical establishments including homeopathic clinics. A liability can rise from failure to diagnose or treat a condition, administration of wrong medication or dosage, failure to obtain informed consent, breach of standard of care, negligence in treatment or management. Homeopathic practitioners can face criminal liability, fine, imprisonment or both, civil liability, compensation to the patients, disciplinary action, suspension or removal from the register, and loss of reputation and credibility in the society. It is essential for homeopathic practitioners to maintain proper records, follow standard treatments protocol, and obtain informed consent to minimize the risk of legal liabilities. The homeopathic practitioners in India have legal responsibilities and duties towards the patients, including duty of care, where they have to provide reasonable care and skill while treating the patients. Then informed consent, obtain patient consent before treatment, disclosing the risk and benefits, confidentiality, maintain patient's confidentiality and privacy, documentation, keep accurate and detailed records of patient's treatment. Fifth is standard of care, follow established homeopathic standards and protocols. Sixth is patient safety, which ensure a safe environment for the patients. Seventh is emergency care, provide emergency care and refer patients to other healthcare professionals when necessary. Eighth is disclosure of risks, inform patients to potential risks and side effects of the treatment. Patients' autonomy, respect patients' right to make informed decisions about their treatment. 10th is continuity of care, ensure continuity of care and referral to other healthcare professionals when necessary. 11th is medical negligence, avoid medical negligence and take reasonable care to prevent harm to the patients. 12th is patient communication, communicate effectively with patients and their families. Legal duties also include complying with relevant laws and regulations, maintaining professional registration and licensure, participating in continuing education and professional development, respecting patients' rights and dignity, avoiding conflicts of interest. Legal duties toward the patients. By fulfilling these legal responsibilities and duties, homeopathic practitioner can ensure they are providing quality care to the patients while minimize the risk of legal liability. Then second component is case laws and landmark judgments. Laws applicable to homeopathic practitioner: National Commission of Homeopathy Act 2020, Consumer Protection Act 1986, Medical Negligence Law, that is Indian Penal Code 1860 under section 304A, section 106 subsection 1, BNS 2023, the Drugs and Cosmetic Act 1940. Case laws, and there are certain landmark judgments. Landmark judgments: Poonam Verma versus Ashwin Patel in 1996. Supreme Court held homeopathic practitioners liable for medical negligence. Supreme Court held respondent 1, a homeopath, liable for negligence per se despite lacking qualifications in the allopathy. He prescribed allopathic drugs leading to the patient's deterioration in 24 Jan 2024. Dr. R. K. Chaudhary versus State of Rajasthan 2013, Rajasthan High Court emphasized the importance of informed consent. Third is Dr. Suresh Gupta versus Government of NCT of Delhi 2004. Supreme Court established guidelines for medical negligence cases. Supreme Court held that for the conviction of a doctor on charges of criminal negligence, there should be deliberate wrongdoing implying a higher degree of morally blameworthy conduct. Kusum Sharma versus Batra Hospital 2011. Delhi High Court held homeopathic practitioners liable for the negligence. Jacob Matthew versus State of Punjab 2005. Supreme Court clarified the concept of medical negligence. In the landmark judgment, the Supreme Court of India laid down guidelines in cases of alleged negligence against the medical practitioners in India. It clearly stated that there is a need for protecting doctors for frivolous or unjust prosecution. Case laws and landmark judgments. Jacob Matthews versus State of Punjab 2005. The above judgment gives relief to the medical profession. However, no immunity is conferred. The judges have left to the central and state governments to give rules and regulations, as in India it is a state subject. These guidelines prescribe opinion from a proper government doctor before proceeding against a doctor. The accused doctor can present his defense by obtaining from expert of choice after a case is charge sheeted and the case comes before the court for examination. These laws and judgments emphasize the importance of maintaining proper records, obtaining informed consent, following standard treatments and protocols, avoiding medical negligence, respecting patients' rights and dignity. Homeopathic practitioners must be aware of these laws and judgments to ensure they are providing quality care to their patients while minimizing the risk of legal liability. Regulatory bodies and their functions. Here are the regulatory bodies and their functions related to the homeopathic practitioners in India. National Commission for Homeopathy Act 2020 regulates homeopathic education and practice, maintain a register of homeopathic practitioners, prescribes standards for homeopathic education and practice. Regulatory bodies and their functions. State councils of homeopathy regulate homeopathy practice in their respective states, maintain a register of homeopathic practitioners in their states. Medical Council of India, that is MCI, which regulates medical education and practice including homeopathy, maintain a register of medical practitioners including homeopaths. There is a Ministry of Ayush which oversees homeopathic education and practice. It develops policies and programs for homeopathy. There are regulatory bodies and their functions like state health departments implement health policies and programs related to the homeopathy, oversee the homeopathic clinics and hospitals. Regulatory bodies and their functions. These regulatory bodies ensure that homeopathic practitioners should meet the educational training standards, follow the standard treatment protocols, maintain the proper records, obtain informed consent and avoid medical negligence. By regulating homeopathic practice, these bodies aim to protect the public health and ensure the quality care. As our second lecture is legal responsibility of homeopathic practitioner. The legal responsibility, as we have discussed, it has got four components, that is medical negligence and malpractice, legal duties towards the patients, case laws and landmark judgments, and there are certain regulatory bodies and their functions. In this medical negligence, we have to have, when you are serving, the deficiency and failure to execute the reasonable care towards the patient, it should not be happened, and the negligence can be divided as an act of omission and act of the commission. There are reasonable circumstances which we came across as a practitioner, but we should not deny this in or come under the medical negligence, or we should not go for the malpractice. The medical negligence, that is negligence of the duty, then causing the damage to the patient, and the medical practitioner should have the reasonable care and the support and give the treatment to the patients. There are certain examples which are given, which are discussed previously, we will just revise it, like applications of the burns which happens because of the hot water. Then there is some breaking of the needles while giving or while treating the patient. It may happen that there are certain needles which may break, which will be applicable as a malpractice or negligence towards the sufficient care of the patient. Then blood transfusion, this is also very serious topic where we should be careful while doing the blood transfusion. Application of the tight plaster which causes discomfort to the patient can, or this plaster cast can cause the gangrene. These are the certain examples we have discussed. We have the professional negligence which can be divided into two parts, that is criminal negligence and civil negligence. We have discussed, that is defense against the medical negligence is calculated risk which, and there is a vicarious responsibility also, and there is a contributory negligence and corporate negligence. Then products liability, whatever you are prescribing, whatever you are applying, whatever you are dealing, you should have a quality products. If or whatever you are prescribing to the patient, you have a product's liability. You are responsible to, or you are reasonably responsible to give the product's liability. Therapeutic misadventure, error in the judgment, all these are the important points we should not miss as a physician. Precautions to avoid negligence care. Doctor should be get informed consent from the patient. Wherever you are dealing with the patients, you should take the informed consent, that is a permission to give the sufficient care or whatever treatment you are giving to the patient, you should have a consent or information which is duly signed by the patient. By taking the patient into your confidence, you can develop a sufficient rapport, and you can develop this rapport which is necessary in the daily practice. You should take care of patient like there is a initial era of family physician concept, that you should be establish or develop a rapport with the patient, so that the patient can feel the trust towards the doctor, and this is how you can develop the doctor patient relationship. Then you should keep full and accurate medical records. When the patient came, time of arrival of the patient, who brought the patient, what is the chief complaint of the patients, what was the present status of the patient, what is the past history of the patient, what patient is taking medications, whether his diagnosis is done properly, what kind of diagnosis and from where he did that diagnosis, whether he is able to communicate with you about that diagnosis, and what is the past history, what he is going through previously, then what is his family history, what was the family history he is belonging to. All these records will necessary for the further process, and you can give the accurate diagnosis, and you can plan the next treatment of the patient by keeping the proper medical records. And if some mishap happens, you can directly, this record can be put in the court of law as a documentary evidence in the court of law. Employ the ordinary skill and care throughout the treatment. You have to have some patient communication skill, diagnostic skill, and develop the rapport. So, it is called as something special event. You have to attend and do the necessary things. Whenever you have necessary investigations, you have to suggest. If the patient is asking you for the investigations, then also you have to suggest, and if the patient is not asking, but you require for the diagnosis, you have to suggest the investigation, that should not be ignored for the final diagnosis. So, you can come to know the where the disease is progress and what is the period you require to treat the patient, because patient also ask you about the how long he should take the treatment. Then immunization, tetanus, wherever necessary, you should ask and suggest, and even if the patient asks you, you should suggest for the same. If the patient is hypersensitive or sensitive towards some certain kind of treatment or allergic, you should think about the sensitivity to the sufficient care of the patient. Then if you are not able to handle such kind of cases, or your experience is lacking in some of the cases, you should take the opinion of some senior consultant or opinion of your colleague, and you should not feel anything bad about it while taking the opinion of the other doctor, so that the diagnosis or the opinion will help the patient for further progression. Then in a suspected case of malignancy, or necessary test should be done before the injections. Before giving any injection like sensitive dose, sensitive test, some amount preparatory dose, you should try and give to the patients. Then if the patient is in the bad situation, bad condition, or is the decision conditioning is worsening, this information should be shared and informed to the relatives if the patient is critical. You should not hide any information from the patient and from the patient's relatives. Then you should not give too much promises to the patients. This means that you should not give that everything will be cured, you will be guaranteed 100%, and you should not give any time limit that within 2 months, within 3 months, if you take care, I will 100%, I will guarantee that you will be treated positively. Do not give such kind of promises or false promises to the patient. You cannot give any guarantee for the any cure. So, you should be taken care of. Each step of the treatment, it should be conveyed to the patient properly. Whatever steps you are planned, what is the prognosis of the case, everything should be planned properly, and all the information should be given and conveyed to the patient as well as relatives or the attendant, so that you will be at the in the safe hands. Then whenever the patient requires, you should give the adequate facilities for the treatment of patient. If that facility is not available with your OPD basis or at your level, you should refer the patient to the bigger institutes or where all the facilities should be available. So that if the patient's conditions worsens or the patient is in the critical condition, he can take care of this. Then in certain cases, patient might require the multi-stage treatment. So, he is suffering for 2 or 3 conditions or something like that. So, you should give the specific treatment, and if the specific treatment has some other protocols, you should arrange for the separate consent form. In one consent form, you can treat one things, or whatever the things complete under that consent form, you should treat that. Otherwise, you should give the separate consent form. When the new drugs is administered, or if you are doing any research in such cases, or if you are administering something, you are giving something to the patient, that you should follow the ICMR guidelines, which is compulsory and which is mandatory for the research purposes also. Whenever the operative procedures are happening, the operator chair should be clean and sterilized, and it should be infection free. That may cause the major medical negligence or considered as a major malpractice towards the sufficient care of the patient. Then in cases of you are writing about the differential diagnosis, then what is the reason, what symptoms you have observed for the differential diagnosis, what are your clinical findings, you should mention this. Supporting the same, you should keep meticulously record why you are saying or why you are giving these reasons for the diagnosis purposes. You should keep the meticulous records for the same. Once you come to the final diagnosis or possible final diagnosis, it should be mentioned or it should be recorded and give your valuable evidence of the same. Every medical act must be accordance and prevailing the practice acceptable doctors of that specialty. So, you cannot be an expert of every field. So, whatever the field or the expert or person of that field, you should not feel anything ashamed of taking the opinion of your colleagues for the betterment of the patients. And once you are referred the patient, you have taken the opinion, you should take the medical records of the same. Even if you refer the patient for the sonography report, UHG sonography, you should advise in your case record that you have referred this patient. So, there should not be in the lacuna while giving the treatment to the patients. Then so many patients have we have discussed about the medical insurance also. So, the intention of is to you should get the protection as a professional doctor, you should get the care and the support from the insurance, and patient also gets some compensation from the under the this insurance. Then so many acts were discussed that under which the homeopaths can be punishment, that is Indian Penal Code, we will just revise about it. Then causing the grievous hurt to the patient or causing death by the neglection of the patients. Then we have discussed many things about the Consumer Protection Act, that is which was established. Then under the Consumer Protection Act, homeopathic practitioner can be held liable for the deficiency in the service. So, whatever the medicines you have, you should always check the whatever you are prescribing to the patient. Then Medical Council Act 1956, this also gives the homeopathic practitioner registered under this act can face disciplinary action for the professional misconduct. Under this, National Commission of Homeopathy Act, which was established in 2020, regulates the education and the practice and provides disciplinary action against the practitioners. There are 3 principles that of the homeopathy: the law of similars, the individualization of the case, and the minimum dose. So, law of similars explains that like yours like, similia similibus curantur, we are aware of it. Then individualization is our base. So, individualization of the case taking, record keeping is very important. Whatever dosage you are prescribing, how many repetitions you are giving, and in the which form you are giving, that should be mentioned and recorded properly. Medical negligence and malpractice, liability can be arise from failure to diagnose or treat the condition. If you are not self-sufficient and if you are fail or you are not able to diagnose the patient, you are not able to treat the condition, you have to find out the cause and the diagnosis. So, in that basis, once you diagnose the patient properly, administration of the wrong medication dosages can be avoided, and if you avoid this, you are not liable for the punishment. So, administration of wrong medication, if your diagnosis is perfect, you are going on the proper line. So, to understand the line of the treatment or prognosis of the patient and to take the sufficient care of the patients, first step is the right diagnosis with the right opinion. Then once your diagnosis is right, you can give the right medications, so you can avoid the chances of liability for the punishment. Third thing is, you have to obtain the informed consent. Whatever the disease or the condition or the patient status you are treating or taking, putting your hand into that and taking care of that patient, you should be aware of what you are dealing with, and your patient is also aware of what you are doing with, because all these complaints, patients should not complain about the negligence to the sufficient care in the treatment. Homeopathy practitioners can be face some criminal liability, like they also can face the fine in the form of liability, then imprisonment, or in certain cases both the fine also and the imprisonment also. Then there are certain civil liability also may happen in the while dealing with the patients, that is the compensation to the patients. If you are not able to diagnose, if you are not able to give the treatment, you are not giving time schedule or time period or planning of the treatment, and if the patient is suffered or something went wrong with the patients, you are liable for the compensation to the patient. Then disciplinary action, the council can or the institute can take the disciplinary action against the suspensions or removal from the name of the registration. So, suspension of the duties if the person is working with the government institutes, and removal from the register if something major happens with the on the part of the patient, then your name will be removed for the registration. Because of these two things, suspensions and removal from the register, this will give the loss of reputation and credibility in the public and also in the society also. It is essential for the homeopathic practitioners to maintain proper records, follow standard treatment protocols, and obtain informed consent to minimize the risk of legal liabilities. Then legal duties toward the patients, what we have discussed is duty of the care, provide reasonable care and skill while treating the patients. Then informed consent we have discussed. Then confidentiality, maintain patient continuity, that is called as a professional secret also. Whatever you are discussing or the patient is discussing with you, that should be kept confidential. Maintain the proper confidentiality and privacy of the patient, and you have to respect that privacy of the patient. Documentation, keep the accurate and detailed records of patient's treatment. Even if the patient comes after the years or some days or some months, you should have the document with you, and that should be the accurate document. Whatever you are providing to them or whatever they are providing you, and which date, what they are coming, with whom, what are his initial complaints, which help you and guide you for the further process. So, documentation is, and these are your legal duties towards the patient. So, while treating the homeopaths also, you are handling with the patients, handle with the standard care, that is follow established homeopathic standards and protocols. Patient safety we have discussed, do the environment or a safe and comfortable environment to the patient and understand the patient's safety while dealing with the patients. Then in sometimes you have to understand the emergency care also needed. To provide the emergency care, refer the patient to the other healthcare professionals whenever they are necessary. Why you are referring? Give the idea or guideline, because they need some emergency care which will be available at the bigger institute level. So, to that care or that emergency needs, you have to understand by your profession, you have to refer that patient in some relation. Then disclosure of the risk, inform the patients about the potential risk and side effects of the treatment. Whatever you are giving, there are some symptoms which might be increasing, so and it will subside on its own. So, you should inform the patients about the potential risk, what you are putting into the patient, you have to understand this. Respect the patient's right to make the informed decisions and their treatment. So, if they want to continue, if they want to shift, or if they want to take presently for this complaint and afterwards he deal with the another complaint. So, the patient's autonomy, you have to respect that autonomy of the patient, that is the right of the patients. Continuity of the care, ensure the continuity of the care and referral to the healthcare professional whenever necessary. This treatment required some time, the doctor also have to have a patience and the patient should have a sufficient patience, because some treatments require longer duration or continuity of the care. So, in such cases you might require to refer the patient some other professionals whenever it is necessary. To avoid this medical negligence, take the reasonable care to prevent the harm to the patient. While referring for giving the continued long care to the patients, you should avoid the harm or prevent the harm to the patients. Patients' communication effectively with the patients and their families. These legal duties also include complying with the relevant laws and regulations, maintaining the professional registration and licensure, participating in continuing the education of the professional development, whatever upcoming treatments, upcoming developments in your field, you should be aware of it. Then respecting patient's right and dignity, whatever the patient is asking, opinion, reference or sufficient care, you should respect the right and dignity of the patient. By doing this, you can avoid the conflicts of the interest. By fulfilling these legal responsibilities and duties, homeopathic practitioners can ensure they are providing quality care to their patients while minimizing the risk of liability. There are certain, we have discussed about the care and the laws also. So, these laws are applicable to the homeopathic practitioners also. This is we are just revising, that is the Consumer Protection, National Commission on Homeopathy Act, Medical Negligence Law, Drug and Cosmetics Act. Then we have discussed about the certain landmark cases and landmark judgments. From that landmark judgments, we should aware of and we can prevent the negligence toward the taking the sufficient care of the patient. We have discussed certain cases like Poonam Verma versus Ashwin Patel. Then we have discussed cases like R.K. Chaudhary versus State Government of Rajasthan. We have given the example of the Dr. Suresh Gupta versus Government of NCT of the Delhi. Kusum Sharma versus Batra Hospital, that is the Delhi High Court held homeopathic practitioners liable for the negligence. Example was given about the landmark judgment, the Supreme Court of India and laid down the guidelines in cases of alleged negligence against the medical practitioners in India. Clearly stated that there is a need of protecting doctors from the frivolous or unjust prosecution. This was the famous case what we have discussed is the Jacob Mathew versus State of the Punjab in 2005. This gives some relief to the medical profession and some courage, so that this judgment is given by the governments following the rules and regulation, as India is a state government and every state has a different connections laid down by the IPC. These guidelines prescribe opinion from the proper government doctor for proceeding against the doctor. Doctor should not be put in as a accused doctor in such kind of affairs, and doctor also had some values should have and stand for his valid defense. These laws and judgments have given the components like maintaining the proper records, obtaining the informed consent, following the standard treatments and protocols, then avoiding the medical negligence and respecting the patient's right and dignity. As we have discussed and revised that maintaining of the records is a key factor. Obtaining the informed consent is most important things in avoiding the negligence. You have to have a standard protocols of the treatment, that this case will be treated like this. Then avoid medical, so that if you are following the above all three records, consent and standard protocols, you will avoid the medical negligence to take the care of the patient. Respect the patient's rights and dignity, as we have discussed. Homeopathic practitioners must be aware of these laws and judgments to ensure that they are providing quality care to their patients while minimizing the risk of legal liabilities. We have discussed there are regulatory bodies and their functions. So, which are these regulatory bodies? National Commission on Homeopathy Act 2020. What their role is, we will revise is regulates the homeopathic education in the practice, maintain the register of the homeopathic practitioner, prescribe the standards for the homeopathic education and the practice. There are certain regulatory bodies and their functions like State Council of Homeopathy, which regulate the homeopathic practice in their respective states, then maintain the registrar and homeopathic practitioner in their states. Then Medical Council of MDI, which regulates the medical education and practice including homeopathy, and they also have to maintain the register of the medical practitioner including homeopathy, which is mandatory to all the professions of the medical. Then there is the Ministry of the Ayush, oversees homeopathic education and practice and develops policies, programs of the homeopathy. Then while deciding the policies and programs, they introduce the new courses, how to implement new courses, then their training programs are taken, how to implement it, or what is the outcome you are giving to the patients or what you are giving to serving to the society, what is the so many policies and programs are done under this Ayush. State health departments, they also implement certain health policies and programs which are related to the homeopathy. Then they look after the homeopathic clinics, their roles, their protocols and how they are implemented homeopathic clinics and hospitals. The regulatory bodies ensure that homeopathic practitioners meet educational and training standards, follow the standard treatments and protocols, maintain the proper records, obtain the informed consent, avoid medical negligence. By regulating homeopathic practice, these bodies aim to protect the public health and ensure the quality care. Thank you.